Welcome, everyone. It's a pleasure to be here today to moderate the panel, Antitrust by Algorithm. Today, we have two amazing guests. We have Professor Cory Colignazzi. Professor Colignazzi is a professor of law and a professor of political science at the University of Pennsylvania in the US, and where he is also the director of the Penn Program on Regulation. And we also have today Professor Michelle Gal, who is a professor of law at the Faculty of Law of Haifa University in Israel. She is also the director of the Forum on Law and Markets there. Our panel will be structured in the following way. Professor Colignazzi will start by giving us a 20-minute presentation on the topic of antitrust and algorithms. And later, Professor Gal will give a brief commentary on the topic. And of course, we will be hearing questions from the audience. So please write them in the chat or in the Q&A tool. So without further ado, Professor Colignazzi, the floor is yours.
Thank you very much, Lisa, for the introduction. Thibaut, thank you for the invitation to be here today. I'm going to share my screen. If someone could give me permission to do that, that would be great. And I'm going to talk about a paper that I've co-authored with Alicia Lay, who is joining me on the paper, but not on this presentation, unfortunately. But I will, I want to give credit to her for everything you like about the paper, and I'll take the blame for everything that you don't like about the presentation or the paper. So the paper is Antitrust by Algorithm, and what I want to do is just provide at the outset a brief overview of the argument that the paper makes. That first, that business is changing, especially in this digital economy, where the private sector is relying increasingly on artificial intelligence tools. And that development in the private sector means that to keep pace, antitrust authorities are going to need to increasingly rely on these same digital tools. And that reliance on artificial intelligence or machine learning algorithms is what I'm referring to as antitrust by algorithm. It is, the paper is somewhat agnostic about substantive legal standards and whether they need to change, although I think we're likely to see that happening as well. But in some sense, irrespective of the legal standards, anywhere around the world, we think that these changes in the private sector will mean that public antitrust authorities will need to rely on similar tools to enhance their monitoring and analysis of the private market behavior. And then in making that shift to an increased reliance on algorithmic tools, antitrust authorities need to meet a series of institutional challenges, which is a principal focus of the paper. And I'm going to talk about building organizational capacity within an antitrust authority and avoiding legal pitfalls, and then also ensuring public trust. There's been as much controversy as there might be around antitrust these days. There's considerable controversy over the use of artificial intelligence tools by public sector organizations. And I think antitrust authorities won't be exempt from that, that controversy if they rely on antitrust by algorithm. So let me just highlight what is certainly evident to, I'm sure, everyone here. The new business environment relies on increased complexity and automation by private sector algorithms, whether it's differential pricing algorithms, algorithms for salaries, self-preferencing algorithms. There may be just even more complexity in terms of the digital economy being new and harder to understand and monitor than more traditional, well-studied sectors of and parts of the economy. This also means that private actors will have not only new ways of transacting that can be for the public good and for increasing efficiency in markets, but also possibilities for colluding and evading. And that means new challenges then for antitrust authorities in detecting illegal anti-competitive behavior. Now, we don't mean to suggest, I don't mean to suggest at all that all of algorithms used by the private sector are inherently anti-competitive, that they can't be productive in advancing consumer welfare. Quite the contrary. But I do think that these new developments in the marketplace can make it easier for firms to evade detection, or may create new kinds of opportunities for anti-competitive outcomes and behavior. And so that means that I think that antitrust authorities ought to see algorithms not only as potential problems when they're used in the private sector, but also opportunities for themselves in performing their missions. To some extent, algorithms can also help with solving persistent challenges facing antitrust authorities. And any regulator faces this. The fact is that there are many, many more market actors and transactions than there are, auditors, inspectors, and regulators to oversee those markets. And when they're changing quickly, that makes these challenges even more difficult. But algorithms may be able to help overcome some of these more persistent or inherent challenges, as well as to keep pace with the changes that are happening in the private sector with industry's use of algorithmic tools. And we see that other governmental authorities and regulators are using artificial intelligence for these very purposes. There have been a number of studies in recent years. One excellent work out of Stanford, actually, by David Engstrom and Daniel Ho and some collaborators, about how the federal government in the US is using artificial intelligence tools in a wide range of areas. One of the most frequent uses at the federal level that they document is in enforcement. And so we see, for example, the use of artificial intelligence by tax and revenue raising authorities seeking to identify taxpayers who may be evading taxes, and then to be able to target the auditing resources to those taxpayers who are more likely to be evading taxes. Securities regulators are using artificial intelligence to identify fraud and insider trading. Again, in the current uses, these are being used to guide the discretionary authority about which firms to target for greater human oversight and auditing, but they can really be quite helpful in that regard. We also see various healthcare funding authorities using these tools and having them used to identify medical fraud as well. In all of these instances here, this is used again for targeting, but that can be obviously a very important and useful tool for regulators of any kind. In fact, what we see is that in these contexts, artificial intelligence does achieve demonstrable improvements. There's research. The last panel was asking about evidence-based demonstration of the possibilities with artificial intelligence. And here we have it in other contexts. Environmental regulators, in one very good study, show that by relying on machine learning algorithms to identify potential violators of water pollution regulations, they could identify 6 times as many violators with the same level of inspection resources as before. There's a very nice recent study with an effort in Greece where border officials have used artificial intelligence, machine learning algorithms to try to identify at airports those passengers who may be entering the country who are asymptomatic but positive for COVID, and demonstrate that the use of the machine learning algorithm is able to increase the efficiency of identifying those asymptomatic COVID individuals 2 to 4 times the rate of what they could normally do. Other studies have shown that regulators that are enforcing the bycatch restrictions for fishers who go out into the ocean and have to limit the number of non-approved fish, that they can improve their detection of that through artificial. So there is sound research behind this move toward reliance on algorithmic tools. And that gives rise, I think, to optimism that this would also be promising in the antitrust area. Obviously, we're seeing growing interest by antitrust scholars here at this particular conference in applying these tools to antitrust. I think there's growing recognition of the role for machine learning analysis in economic research and estimating counterfactuals, for example, and the need for more dynamic modeling in general. And there is some early movement by various antitrust regulators around the world to at least begin to start to study AI tools within industry. The UK has initiated an office to start studying this. The U.S. Department of Justice in the U.S. here in the U.S. has indicated that they're moving in this direction, and I'm sure many of you are here at this this conference because of that that movement and that interest. So, if we're going to be shifting toward a world more of antitrust by algorithm, what does it mean? How do we get there? How do we implement? I think the key question in any before going forward with any use of machine learning algorithms is simple, to ask a very simple, straightforward question, and that is, can the machine learning algorithms do better than the status quo? We know that human judgment and conventional analyses driven by humans have their limitations. And in some situations, machine learning algorithms can do better, as the evidence that I've reviewed already indicates. But that's not going to be always the case for every possible use of algorithms. So we always have to keep that key question in mind. And then I think it helps to think also about what are 2 key preconditions for relying on machine learning algorithms in any context, but certainly in the antitrust area as well. I mean, these algorithms by necessity need mathematically precise goals that are built into the objective functions of the algorithm, and they also rely on big data. And if the use case that you're contemplating doesn't really have a very well specified goal, if it is simply something about what Cass Sunstein once called incompletely theorized agreements that, we want to try to identify unreasonable behavior, for example, or undue restraints on trade. If that's the degree of specificity, then it's not likely to work. We've got to really get this down into some mathematical form. And then we also need, available data that's current and that will, yield accurate predictions in the end that will answer the key question that the algorithms would do better than the status quo. Assuming that that's the case in some domains for a non-trivial number of questions or uses within antitrust authorities, then I think there's three institutional challenges that the authorities will face. The first is to build organizational capacity for undertaking this. The GAO here in the United States, the Government Accountability Office, has a very nice framework for the development of AI tools by government authorities, and it highlights the process of designing, then developing, and then deploying, and ultimately also monitoring and use continuously algorithms. To engage in that kind of process, it's important, again, to have the data availability, also to have the capacity to store and analyze data. And a lot of public sector organizations are unfortunately not always fully equipped with the kind of computing infrastructure that's needed. So that's certainly going to be part of building an organizational capacity for this. If this data is sensitive as market data, then you're going to need to deal with privacy and cybersecurity protections and make sure that's. And of course, you're going to need expert human capital, not only data scientists, but data scientists who are aware of and sensitive to the particular challenges of applying machine learning algorithms in the governmental context. And sometimes that human capital, of course, might be obtained from private sector firms who contract with the government, and the procurement process there needs to be well thought out and anticipate the possibility down the road that that there may be a need for some kind of disclosure to the public about how, or to courts about how an algorithm was designed. And that will be one strategy in avoiding some legal pitfalls. Now, I think there's not inherent legal pitfalls from machine learning algorithms. In fact, for a lot of the uses that an antitrust authority might rely on for basic research, there really aren't going to be legal risks there. But even with respect to, by the way, enforcement targeting, as long as humans are following up, probably the legal risks are low. But as we look forward and we consider the possibility of greater automation, human potentially out of the loop systems, we can anticipate that some litigation will arise. It has in other contexts when government authorities have used machine learning algorithms. And I think that two major sets of arguments that come up are center on transparency. These are considered black box algorithms. It's not as intuitively obvious what explains the outcomes that they arrive at. So there's some transparency issues, and there's concerns about possible discrimination or bias, particularly when data themselves have those bias. I do think there's solutions to these. Best practices in validating, documenting, and disclosing what can be disclosed can address a lot of the transparency concerns. And there are ways of engaging in algorithmic impact assessment to try to identify possible biases and eliminate them. I do think, again, that this is an area where we have to recognize that there are going to be public concerns in many contexts, both about antitrust and its future and about the use of artificial intelligence by government. But there are ways to kind of minimize conflicts and controversies. I think it's very important to validate outcomes. So the last panel's point about evidence-based is really important, and to try to anticipate the impacts that the algorithms would have. There are best practices. So if you're not already familiar with, for example, the OECD principles on artificial intelligence, that would be one place to look. Committing to as much transparency as possible is important, and making sure that these algorithms are developed with involvement of others, whether it's through peer review or, if possible, public consultation. Let me wrap up by just highlighting again that we're in a world which is rapidly changing and increasingly digitized. And that means that antitrust by algorithm can be part of that market oversight in that world. Obviously, that's going to need data and computing capability, but more than just technology and data, I think moving ahead with antitrust by algorithm also requires responsible human decision-making about when and how to use these tools. And if we do so, I think that can improve the performance of antitrust authorities, as it has with other regulators, and it can also avoid legal pitfalls and maintain public trust. Thank you very much. I look forward to the conversation.
Thank you so much, Professor. Now we will hear the comments from Professor Gal. Thank you so much.
Thank you for inviting me, and thank you for this wonderful project, and Thibault for leading, the part about computational antitrust in such a inspiring way. So let me share my screen. Okay, I hope that it's visible. Can you see my PowerPoint? Yeah, great, wonderful.
Yes.
So I enjoyed the paper very much. Thank you so much. And I completely agree with the three premises that it makes. The first one is that algorithms create complex competition problems. The second, that there's a need to use tools that that are fit to the task, algorithms by regulators. And third premise is that using algorithms poses institutional challenges. I will add some thoughts to each, but I will also take upon myself a fourth task, and I would also relate to some limitations of the use of algorithmic regulators. Sorry. So let me just say a word first about the motivation. Some statistics here, the use of algorithms by firms in the market. What are we facing? So that more than 50% of retailers in the US are using pricing algorithms. 67% of EU firms who track their competitors on a daily basis did so by using algorithms, and 35% of them used automatic repricing algorithms. And more than 1/3 of the best-selling items on Amazon.com were priced by pricing bots in 2014, 2015. So as we can see from these statistics, and this is only with regard to pricing algorithms, there are many other types of algorithms as well, but I just wanted to give you a flavor to add to the importance of using computational antitrust. So the first premise of the paper was that algorithms create complex competition issues. And let me add to that, that first of all, I think we should relate to the whole ecosystem. It's the connectivity, it's the big data, it's the algorithm. Because big data, for example, might create natural comparative advantages like network effects. So all of these contribute to the complexity. And let me offer this typology, which I hope you will find helpful here. I think that some uses of algorithms, you can say that simply increase competition concerns. And one example here is the use of algorithm in order to carry out traditional collusion. This is this case, a very famous case of the Tompkins case, in which sellers of posters of online engaged in a cartel, and they carried it out via an algorithm. This case is also mentioned, of course, in the paper. These are relatively simple cases. Some other cases are those in which the algorithm increases the harm. Okay, so you have the exact same competition offense. However, once you use an algorithm, the harm is increased. For example, algorithms might create, under some market conditions, more stable cartels. Another use of algorithms by markets are those in which the welfare effects are debated, so that not all uses of algorithms, even those which harm consumers in the short run, necessarily everybody agrees that affect competition and therefore should come under competition laws. And one example here is personalized pricing. And the last case here, I think, is that some algorithms, the use of some algorithms might create new competition concerns. And I will get to this at the end when I talk about autonomous algorithms. Second premise that the paper makes is the need for algorithmic regulation. And I completely agree. I think this is extremely important. We are already playing catch up with technology. We have the technology, or it can be developed. Of course, this would require a lot of investment of resources, but the tools, many of them are out there. And sometimes you need an algorithm to best another algorithm, because if one side enjoys speed and sophistication, you might need speed and sophistication on your side as well as the regulator. And another point here is that this type of regulation takes advantage of the nature of the algorithm which is used by firms, because such algorithms create transparency of decision making once you can see what the algorithm is. Okay, and that makes a regulation sometimes easier. Of course, the algorithm can also be used to design and supervise remedies, as Thibault has so rightly said before. The third premise, and once again, I agree very much with it, is that there are institutional challenges here. But the first question that I think we should ask is, how different is this in the antitrust sphere from other areas of law, or from other regulatory tools that were introduced in the past and were new to the antitrust sphere? Because I think there's a lot to be learned from the introduction of new methodologies in the past and from introduction of algorithms in other spheres. So we don't actually need to think every time anew of these institutional challenges, but rather we can learn from past experiences. So just a few pointers here. One is with regard to building capacities. I think from my experience of writing on some of these subjects, it's really important to create a common language of lawyers and economists and data scientists, because sometimes the definitions and the expectations and the requirements are different when you come from different points of view or from different fields. And they need to talk the same language so that we don't create an internal Tower of Babel. I think it might be useful to build cases bottom up, from easy ones to more difficult ones. It might be useful to have crossovers with other antitrust agencies, I mean, it's the UK CMA is already experiencing with this, and it already created some kind of algorithms to detect some kind of behavior. It won't necessarily only work on the UK market. It might work on other markets as well. And actually, that might be a way of overcoming some of the resource problems here by joining forces, maybe even with other sector-specific regulators. Now, of course, every use here should be based at least on a medium-run cost-benefit analysis. It doesn't make sense to use algorithms and create them for everything and anything. I think that this already came up in discussions. And one more thing is data standardization. I think that Margaret has so rightly said that sometimes the data that different firms collect is collected under different standards of collection, and it doesn't talk with each other, or the regulator might not understand it, or might not have sufficient information on what exactly the data points are. So sometimes we might want to think about use of data standardization here. Avoiding legal pitfalls for reliance. Here, I think it's important to think how important it is to need the human in the loop. Okay, it might be important, and it actually connects to the third point of building public trust as well. And I think that the question of explainability is an extremely important one, because what exactly does the regulator need to explain? At what level does he need to explain? And if the regulator needs to explain how the algorithm reached the decision, but the firms in the market do not, does this not create some kind of imbalance? And for example, I would say that explainability might be not as needed when you seek which cases to bring, or you seek divergences compared to cases where you use the algorithm in order to prove the existence of, for example, an agreement in restraint of trade. With regard to building public trust, I think one question we might ask here is, should it necessarily be prior to the first use of the technology? Or maybe we can build some good cases and then build trust based on them, okay, a timing issue. Finally, I want to say a few words about the limitations of algorithmic regulation, because one question I think that we should ask ourselves is, will we lose what we gained by the speed and sophistication of using algorithmic regulators once cases comes to court? Okay, because you know the agency is only many times it's only it's a very, very important stop, but it's not the final stop in many of the cases, antitrust cases. And here judges would need to understand the complexity, which might be based, for example, on statistical inferences or machine learning or even deep learning analysis. Okay, so how do we create a situation where judges are open and to such understanding? One way to go around it is maybe to create specialized tribunals, or to create new methodological presumptions with regard to these new tools. And also, I think that for speed and sophistication, we can use more use of interim measures once the algorithmic regulator indicated that there is a serious antitrust problem. Another final problem here is that some conduct is not captured under competition laws, even if it is harmful to competition and to consumers, and it is carried out by algorithms. And here the example is autonomous algorithmic pricing, where you have an algorithm when you say to the algorithm, simply increase my, maximize my profits. And the algorithm determines this by itself. And the question is, of course, can algorithms facilitate coordination? And the answer was given by the OECD 2017. Theoretically, yes. And where we are now is that there are experiments. There are experiments, that there's interesting experiments in that were performed by Calvano and others, which have shown that algorithms can actually learn to coordinate by themselves. This is the price. You see that algorithms increase the price by themselves. And there are many other studies that are now accumulating, which are showing that this is happening in the real world. This cannot be captured by our agreements in restraint of trade because there's no agreement. So what we need here is thinking beyond computational antitrust to changing our laws. Thank you.
Thank you so much, Professor Gal, for that presentation. Now, we have a few questions from the audience. Of course, if you have a question, you can still write it down while we answer the ones we have. The first question is about open source technology. And we're asking, what is the role for open source technology in developing a modular toolkit for algorithm regulation? The question raises the issue of whether open source would be a possible solution to have more less costly way to develop these technologies that will be needed both by the private parties and by the public entities. I would love to hear your comments, both from Professor Colignazzi and Professor Gal.
Sure. I mean, I think, you know, it's worth putting out on the table. I think it's a great question. You know, one of the things that we're seeing with the development of AI tools in a variety of areas, private sector and public sector, is the emergence of a lot of soft law around governing the use of these AI tools. And an open source framework is one process way, really, of developing and managing that governance capacity. It has great transparency. So I think it's a natural question to ask for addressing some of the concerns that do arise when governments and other entities are using AI tools. But of course, you know, if to the extent that this is a tool that is going to be deployed for purposes of enforcement, and maybe, you know, that's not going to be appropriate. There will be limitations on transparency. I think Miguel's question about how much transparency and how much explainability is needed will vary from context to context. And that's true today, even outside of the context of artificial intelligence. I've written this paper called Transparency and Algorithmic Governance, in which I highlight how in the non-algorithmic world, we have, for example, exemptions from the Freedom of Information Act disclosures here in the United States that's required of government agencies when they are dealing with information related to law enforcement. And so transparency and explainability, I think, ultimately is largely pragmatic, and it does vary depending upon the use case. Open source tools might be a really great way of actually developing some industry standards that could be useful for monitoring market activity and standardizing market activity, but it may be limited in other circumstances as well.
Thank you so much, Professor. Professor Gal, do you have any comments on that?
Well, I completely agree. I think that open source can sometimes help, but again, it depends on what is there out there with regard to open source. For example, it would surprise many to know that a deep learning algorithm is now, it can be written in 5 code rows. And so a lot of the algorithms are already out there. The problem sometimes is the data rather than the algorithm, and training the algorithm on data so it will learn from it in the specific case.
Thank you so much, Professor. Professor Koglianese, maybe you want to provide your reactions based on the comments of Professor Gall. Due to time, I think we have a few minutes for you to react.
Oh, well, let me thank Professor Gall for those terrific comments. I really do appreciate them. And, you know, there's a lot in what she said that enhances the argument that we're making in our paper. I think that, you know, the point that she makes about starting with the easy cases before moving on to the more difficult ones is really very important. And I think in some ways, in other contexts, we've missed that a little bit. You know, here in the US, there's a lot of controversy over the use of algorithms, they're not even machine learning algorithms, but use of algorithms in the criminal law setting to make determinations about sentencing and bail decisions, highly consequential decisions about people's liberty, right? And locking them up in jail. And it's not surprising at all that this has generated an enormous backlash. And part of it is, I think, precisely because we didn't really follow Professor Gall's advice. And there's a risk. I think and it's worth putting out on the table here in the antitrust context. There's a risk that any one antitrust authority around the world that goes forward and uses some of these algorithmic tools in ways that are, first of all, highly consequential. They're really deeply relying on it. And two, they're doing so without really competently or responsibly handling the design and validation and execution of the algorithm. That you could generate, any one of the antitrust authorities from around the world could generate a lot of controversy that could actually set back the sort of the cause of computational antitrust for everyone around the world. So I think we need to be aware that this is something to approach with a good degree of care and thoughtfulness and responsibility, because there's a collective good here in using this new approach and these new tools. So I want to really emphasize that point by Professor Gall, starting with the easier cases, building successes with them, being able to validate and develop the institutional capacity to use these tools well before going on and actually tackling the biggest and the most difficult uses.
Thank you so much, Professor. Maybe we have a few seconds just for one last question. I would like to hear comments from you both. The question is, how do you envision these new capabilities being implemented by antitrust agencies as new departments within the organizations, or by adding data scientists to existing departments? And maybe I would like to add, who is going to be training this new personnel to that?
Stanford, right? Isn't that the answer we're supposed to give here?
I agree with that.
Although I will say, just, you know, to piggyback on my last point, I mean, there was a controversy by folks over at the medical school at Stanford in using a machine learning algorithm to determine who should get COVID vaccines first. And it was one of the, it got a fair amount of public attention because it appears, and this is just based upon my reading of the media reports, it appears that the algorithm prioritized vaccines given to those members of the medical school who were most experienced, for example, which makes sense in most contexts, but they were the ones who had the least exposure usually to patients. So if you were looking at it from a risk standpoint, all of these senior physicians who spent most of their day in their offices were prioritized to get the vaccine, and the residents and the doctors who were spending time really with the patients and who had the greater risks of exposure, they were less prioritized. Anyways, it's always to just say that in any organization, if we're not going to approach this with care, we can run afoul of blinders. We've seen this in other contexts. I have a paper called The Limits of Performance-Based Regulation, and regulators have had these blinders in a lot of other contexts over the years. All right, now to the precise question about how should we do this? I think the answer, quite frankly, is all of the above. I think that there are some economies of scale for building some specialized expertise that could cut across different areas within an antitrust authority. But I think you'll also need expertise within individual offices as well. And one thing that the questioner didn't mention, but is also a reality here, is that a lot of the expertise for many public agencies is coming from the private sector. So hiring consultants. And there's a good bit of care that needs to go into thinking about your procurement contracts with these private consultants who you hire. In particular, thinking about the concerns that the Professor Gall was mentioning about how ultimately, if you're using this tool and it winds up in court and it's being challenged, one of the things that the court is definitely going to insist on is good information about how this algorithm has been designed, validated, tested. And some consultants, their normal default is to claim IP protection over everything that they do. And so I think in the procurement process, you have to also be thinking about ahead and making sure that those contracts are written in a way that gives the antitrust authority the ability to, at least in court, be able to disclose more information about how the algorithm functions.
Thank you so much, Professor. Just maybe 30 seconds in remarks.
Sorry about it.
Please. No, it's okay.
It's okay. I think that it depends on how many people you have, because I think that if you only have a few, they should sit together and they should create some tools and be able to talk with each other. Another point, final point I want to make is that what I hear from some agencies is that the problem is getting data scientists and computer scientists, because right now they get very high salaries in the world. So I think that one way around it is to create a strong motivation and for what these algorithms are used for, that you're using it for a really important cause. So both your project is right on point.
Well, thank you so much to you both for this panel. I look forward to reading the article. We will be sure to publish it and let everyone know. Thank you so much.